Deflategate back in federal court today. Neither Tom Brady nor Commissioner Roger Goodell were there, but their attorneys were, and reports are saying Brady and Goodell met for several hours in the morning. Now, Brady might be ready to make a deal. He's reportedly open to taking a reduced suspension in return for admitting he didn't cooperate with the NFL, but that deal wouldn't include any admission that he was actually involved in deflating the footballs or destroying evidence. So you might say, well, why would the NFL go along with that? Well, it might be because the judge ripped the NFL's case apart. He said the 4-game suspension seemed out of line compared to past equipment tampering cases, and he also cited legal precedent for possibly overturning the suspension. But to me, the bigger takeaway, Mayo, was he sent a clear telegram to the NFL to say, listen, I know the CBA, the collective bargaining agreement, lets you basically be judge and jury here, Commissioner. That's fine. But now, if these guys appeal and you go to a court of law, there's a whole different standard you're going to have to make up to. And if you go all the way with this, it's going to open up Pandora's box for every other ruling you do going forward. You would think the NFL says, oh, yeah, I can't even say what they probably said, because this is dangerous if they choose to keep going down this road with Brady.
I think that it's outstanding, and I think that what it does is it does a lot for people who work all over the country. If you're in a labor union anywhere, you have collective bargaining, but if it doesn't work, you have a fresh set of eyes that can look and determine whether there's a fair ground, whether there's an even ground. And it prevents them from being arbitrary and caprice. And you sit and you look at what they're talking about with Brady here, and you're talking 4 games, and you compare that with what Ray Rice initially was going to get for the conduct. It's all over the place. And you also have to stop and wonder if it was a different quarterback, maybe from someplace other than New England, which has such a storied past in terms of, questionable conduct. What's the penalty? What's the penalty for, if you're looking at Eli Manning? Is he going to get the same penalty? So it prevents them from kind of really politicizing it and just going after people unfairly.
I know the judge, Mark, doesn't want to rule in this because he says he doesn't know where this goes. He wants these guys to settle.
He's trying to coerce a settlement. He's trying to force a settlement. I wouldn't necessarily read all of that much into what he's said today. And we've talked a lot of times in the past about the perils of reading tea leaves in terms of oral arguments. Sometimes they posture and the decision can look very, very different from what's being bandied about during the give and take of a 2-hour argument. He's trying to coerce a settlement. And by the way, he's not the final arbiter of this, no pun intended. There's a Second Circuit Court of Appeals, and let me tell you something. His discretion to overturn an arbitration award on the grounds that he's articulating, such as that he thinks it's a bad analogy comparing steroids to deflating footballs, that's way beyond his province and way beyond his role as a judge overseeing an arbitration.
My takeaway, though, was, Jimmy, that everything Mark said, 100%, but it was also that the evidence presented didn't reach, in at least a court of law, enough of a standard to meet the equivalent of a conviction here. And isn't that the bigger takeaway? That, yeah, maybe the logic that he threw out, he was trying to scare everybody involved, but if you go to a court, it's different than the same guy who says 4 games for you. Why? Because I said so, which is basically what the CBA gave this commissioner the power to do.
Well,
if they choose to appeal this thing, Jimmy.
That's right.
They didn't have to sign the CBA.
It doesn't need to be a conviction beyond a reasonable doubt, but he was questioning the factual predicate, but he was also questioning one technical aspect of it, in that there was one person from the NFL that wasn't interviewed, that should have been interviewed, should have been a part of it.
Didn't get to call a witness.
Didn't get to call a witness, and so he did have a technical ground that he also cited. There's no question that he's sending a very strong message, but there's also no question, as Mark said, that his discretion is limited. He really can't retry the facts as easily as he's portending to be able to. So he is clearly sending a message that he wants it settled. He's also sending a message. Remember, you got a football season that's starting.
That's right.
He's sending a message that's saying, I'm probably going to rule, let's just say, I'm going to rule for the NFL. He's going to get to play the season, and the Second Circuit's not going to rule until after the season. So there's a lot of jockeying about in terms of timing here as well.
He's trying to pressure both, but my guess is for you guys, the pressure as it puts on the Patriots here, and also the NFL to both settle. At the end, let's say Brady's your client. Do you say, you listen to what this judge had to say, we're in the driver's seat here. More than 1 game, we're not taking the deal. And no matter what deal we take, if it's even 2 games, we're admitting nothing. Is that the deal you counsel your client to take or no?
I would be somewhat cautiously optimistic about what happened today, but I would also be saying, as a responsible lawyer, what Mark said. At the end of the day, when you're up in Manhattan in the Second Circuit, you can get shot down here. So it's always good to settle. It's always
you also
good
have to be aware of the fact that you've had depositions here, so you're going to be in a position where you have sworn testimony. You do not need to admit things that you denied under oath. So if you can walk away without being put in that position, that's great. At anything less than 4 games gives Brady a victory.
I think Brady, for taking 2 games, is a no-brainer. I think the excruciating choice is for the commissioner, because he has to choose between if he caves on this, the commissioner's office's power dating back to Kennesaw Mountain Landis in the baseball context is severely undermined. Yet, on the other hand, he might not have the appetite to wait out a favorable ruling from the Second Circuit Court of Appeals and allow...
And risk that if the court eventually does see the way of the player here, what that means for all future rules.
There's that risk. And also, the season is coming up, and it's going to be thrown into turmoil. So there's a lot of competing considerations for the commissioner to consider. And if I were him, I would say that the integrity of the office and his role as guardian of the integrity of the sport has to be paramount.
So maybe they split the baby.
It
Maybe
goes
they go for a
beyond
couple
football. You're
games.
looking at hockey, basketball.
Yep.
You're looking at
that's
every
right.
other space.
That's right.
Baseball, all of these sports.
That's why I referenced Landis. That's exactly correct.
Okay. When we come back, you may have seen this story, rape allegations at one of the country's most elite prep schools. But the guy on trial says the encounter was an old school tradition that they even had a phrase for called the senior salute. Does an ingrained culture or tradition make it any more of a viable defense? We'll talk about that after this.